Hi, and welcome to the webinar on Family Emergency Planning, Wills, Trusts, and Wellness. I'm so glad that you made it today. My name is Shane Jasmine Young. I am an attorney and the founder of Young Law Group. For the webinar, I will ask that you complete a worksheet at the end. So you will be able to actually click on the link below, fill it out. It takes 2 minutes and it will be super helpful for me to be able to receive your feedback. I will also be referring to the worksheet throughout the webinar today. I also want you to know that you may be having some questions as we go through this webinar, and you may be thinking about your specific situation, and I want you to feel at ease. Don't worry, you are going to be able to schedule your own complimentary 2-hour session, a one-on-one session with me to talk about all of the specific questions that you have related to your life, your family, and everything that you love. Plus, there's going to be a special bonus at the end when you book your session today. Also, if you do have questions as we're going through the webinar and you want to post them, there is a chat bubble right above here. Just click on it, it opens up, and you'll be able to post any comments or questions as we go through today. All right, so how many of you have done some planning for things like a wedding, birthday party, vacation? That's my favorite thing. But those are things that are fun, right? Well, how many of you have planned for your incapacity or death? When I talk about incapacity, it means really if anything were to happen, if you were in an accident, if you were hospitalized, if you couldn't make your own medical decisions, couldn't handle your financial affairs, couldn't take care of your kids, all of those types of things. So the majority of people actually haven't done planning, about 70% of people. And of those people that do have planning, it's usually not done correctly. There's usually gaps, holes. There's a lot of pitfalls when it comes to estate planning, which we'll be talking about. So for those of you that don't have any planning, why is that? Is it because you're too busy, you're too young, you think it's going to be too expensive? And for those of you that do have planning, what is it that you're hoping to learn today? Are you wanting to get a better understanding of what estate planning really is and how your plan should work? Maybe you did your plan online through LegalZoom or Rocket Lawyer and you're wondering if it's okay. And maybe you did your planning some time ago with a lawyer or maybe a document preparer and it's been many years and it's outdated and you want to make sure that it stays current or it is current going forward. So for those of you that don't have any planning or haven't taken any action, I usually come across 3 reasons why people haven't done it yet. And the first reason or big fear is that by planning for it, it will cause it to occur. And I can tell you that in my experience, that has never happened. So please don't let that superstition keep you from taking action. Number 2 is it's going to take too long or it's going to be too overwhelming. And I can understand that if you've never done any planning and you don't really know what's involved. Number 3 is I'm not old enough, or I'm not wealthy enough, or I'm not old enough and I'm not wealthy enough. And this is really what I hear quite often. And what I would like to share with you is that if you are over 18, so if you are a legal adult, you really should have some planning in place. Now, the typical 18-year-old's planning is going to look a lot different than someone who's my age, in their 40s, has different family dynamics, different assets and things like that. And of course, someone else who may be older or anything in between. You are in the right place if you have someone or something that you care about and you want to protect them. And you're also in the right place if maybe you did your planning, whether working with an attorney, someone else that prepared your documents, or doing your documents online. Maybe they're form-based documents and you don't really know if they're going to work. The reality is when it comes to estate planning, it really should be about the people that you love most, right? And they're going to know whether you lived up to your promise that you took care of things by the action that you take now. Of course, estate planning is also about you, right? You want to make sure that all of your wishes, whatever they are honored in the event that something happens to you. What you're going to learn today is how to protect yourself, protect your family. And I'm going to be giving you several resources. One is a family emergency plan or family profile. This is something that's going to map out really important decisions that you need to make now so that you can get financially and legally organized. We're also going to be talking about how you can avoid court by having a proper plan that allows for private, immediate action. And also healthcare directives is a hot topic now. So making sure that your wishes are clear, comprehensive, and cover things like ventilation or intubation. What you're also going to learn through illustration, through real life stories, is how your loved ones will be able to cope with the unexpected from two different perspectives. The before is the worst possible scenario where you have no plan or a flawed or incomplete plan with maybe just a document here or there. And then the after is the best possible scenario where you have a personalized plan that is tailored, customized to you and your family, not just form documents. We're also going to go over all of the details about how to start the process, how long it will take, and how much it will cost. Plus, there is a bonus at the end, so stay tuned for that. Before we get into the details, I want to share a little bit of my background. So as you know, my name is Shane Young, but before I was Shane Young, I was Young Shane. I actually grew up here in Las Vegas, and I watched my dad, an entrepreneur, savvy businessman, start his own airline. So he got financing, purchased airplanes, hired an attorney, only to have that attorney and some other third parties take control of his airline and push him out of control. They ran the airline into bankruptcy and we lost everything. And as you can imagine, it was financially devastating, right? My dad hired another attorney, filed a malpractice lawsuit against the first law firm and the other people involved. And that lawsuit lasted several years, from the time I was in middle school until I was a sophomore in college. Ultimately, we lost the case due to a technicality, statute of limitations, and I saw the impact that it had financially, emotionally, in every way on my family. And one of the things that I decided was I wanted to go to law school. I wanted to be a lawyer because I wanted to help people so that they wouldn't be in that type of position. So one of the things that I focused on as a young kid was education. I was one of those students that had to get straight A's. I graduated as a valedictorian from my high school. Actually met my husband Charles in high school, so we were high school sweethearts. And you can see a couple of pictures. One at the bottom is a side-by-side of our prom when we were 18, and then my 40th birthday. And I thought that it was just funny that we were posed the same way. It wasn't intentional, but I guess that's what happened when you're together for 25 years. So I graduated from high school, went off to college, went to Pepperdine in Malibu, California. I graduated in 3 years, which was perfect timing because I was 5 months pregnant with twins at the time. So Charles and I did not plan to start our family that young, but it happened, and we both came home to Las Vegas, and I actually started law school on the twins' first birthday. So I graduated from law school in 2004 from Boyd School of Law here in Las Vegas. I went into private practice. I was in private practice for several years. I didn't enjoy private practice because there was a disconnect that I felt with the clients that I was serving. I was having to bill for my time in 6-minute increments. I didn't like that. I wasn't feeling like I was providing value in the way that I was meant to. So in 2017 is when we started our law firm. It's been a little over 3 years now, and it was the best decision ever. One of the nice things about having our firm is that we get to do the work that we love, and the icing on the cake is being recognized for the work that we do, including Best of Las Vegas, Top 40 Under 40, things like that. I mentioned Charles and I are high school sweethearts, and we had our twins right out of college. Well, we had 3 more daughters, so yes, we have 5 daughters altogether. And as you can imagine, my family really brings an awareness to me that the planning that I've done and the planning that you want to do or have done is really for your loved ones, right? Just to make sure that they're taken care of. Now, also when it comes to our other family members, like our parents, my mom lives here in Las Vegas, and fortunately we were able to get her planning updated recently, which was something that was weighing on me, right? You know, our parents and our other family members are getting older, some of them have health concerns, and I want to make sure that I know what needs to be done, what their wishes are in the event that something happens to them, right? And I have a lot of friends and a lot of clients that that come to me and say, I need my mom to get her planning done. I need my grandparents to get their planning done. And they're resistant. And I understand that's a difficult conversation to have at times. So if you are having those challenges, let me know. I'm happy to help. But one thing that you can do is what you're doing right now. Educating yourself so that you can share this information with them, and also going through the process yourself. Book your family wealth planning session now so that you can get the ball moving and you can share your personal experience, your firsthand experience with them. So now that you know a little bit more about me, I want to ask you, who is it that needs your protection? Or what is it that you want to protect? What's important to you? So go ahead and type your answer in the chat box. Share that with me, please. And let's start with the basics of what estate planning is. So when you think of estate planning, many people often think of a will or a trust, or sometimes I hear life insurance, powers of attorney, healthcare directives. Well, those are all pieces, right? Pieces of an estate plan. Really, your estate plan should be a comprehensive plan that addresses all contingencies, from if you are in an accident, if you're disabled, if you're hospitalized, incapacitated, you can't talk to your doctors and express your wishes or decisions. You can't make your own healthcare decisions, handle your financial affairs, pay your bills, take care of your children, what happens to your spouse, your loved ones, your assets in those different circumstances. So that's really what estate planning is planning for all of those contingencies, making sure that they really are covered properly. Now, unfortunately, when it comes to estate planning, it's usually focused on death and not comprehensive. And I saw this in my experience as a first-year attorney right out of law school. I was representing a client named Ada on a pro bono matter, so I was volunteering my time, and she and her family were going through a court process known as probate. So probate is what happens when someone dies and they don't have proper planning in place, or their plan fails, and all of their assets have to move through this court process, which is very slow, it's expensive. I'm going to share some more about that in a moment. But Ada and her family couldn't understand why they had to go to court, because she remembered her father talking years before about his estate plan. He told her that he did his plan, not to worry, he checked that box off. However, he went through a traditional experience where he met with an attorney. The attorney filled out form documents, had him sign, didn't educate him. There was no discovery process. Ada's father didn't really understand how the planning worked. He just knew he had a trust and he felt like that was everything that he needed. However, he didn't inventory his assets. They didn't review the assets that he had. They didn't title them correctly, and they didn't update his plan. So years went by, his plan was never reviewed, never updated. His assets were never tracked and titled properly. So when he died, they ended up in probate court. Also, one of the things that happened was some of his assets ended up in the state's unclaimed property department because his family didn't know about them. So those are some of the things that are very, very common in the traditional law firm or estate planning process. And as a new attorney, I was thinking, well, wow, this is a total fail. This family ended up in court in conflict. The family was fighting. One thing that caused some conflict was Ada's father was married at the time that he put his plan in place and named his wife at the time as a beneficiary. Well, they were no longer together when he died, but he never updated the assets with her named as a beneficiary, and so she made a claim to those assets as part of her inheritance from the estate, and she got them because unfortunately that's how the plan was set up. So I saw this as a new attorney, total fail, and I thought for sure this had to be malpractice. But what I realized was it was actually common practice. It wasn't malpractice at all, and this was just how estate planning is typically done. I mentioned probate court. So probate court is basically where a lawsuit has to be filed. You file it against yourself, your estate, with your own money for the benefit of your creditors and other third parties. So there is zero benefit to you and your family of going through this process. And as you can see, it's very expensive. All of these fees, like appraisal fees, attorney's fees, executor's fees, filing fees, bond premiums have to be posted. Creditors are the first ones that are able to make claims against your estate, and it's slow. We talked about how expensive it is, and it's public. So during this time, anyone can go and see what is in your estate in this probate process, who your heirs are, who's going to be receiving what, and when. So this is oftentimes how predators prey or target people that are receiving inheritances through this process. Also, your assets are tied up and your family doesn't have access to them until a judge issues them to be released. Instead, creditors are the first ones that are able to make claims against your estate. So probate is what happens in the event of your death. Now, the court process that has to be filed if you don't have proper planning and you become incapacitated is a guardianship or a living probate, or maybe you've heard the term conservatorship, and that's where someone on your behalf files a petition with a judge to be appointed to make decisions for you because you can't. So I mentioned with Ada's family how some of Ada's father's assets went to the state's unclaimed property department, and that was because he didn't properly fund his trust. So funding your trust means transferring your assets into your trust. Now think of your trust in this example as a red wagon. So remember when you were younger and you had a red wagon? Well, all of your toys, in order to be safe, should have been in that red wagon, right? So same thing with your assets. Anything you own should be inside your trust. That wasn't the case for Ada's father, and some of his assets, because his family didn't know about them, landed in the state's unclaimed property department. So in Nevada alone, in the state of Nevada, over $830 million of assets are just sitting there unclaimed because usually someone dies and their family has no idea that they exist. So this is one tip for you. In any state that you've lived in, Google that state's unclaimed property department. And in Nevada, you can actually search under your name. So you'll put your name in, and accounts or assets that match your name will actually pop up, and you'll be able to see if there are any assets that the state is currently holding that you can submit a claim to receive. So whether it's $100 or $100,000, that's your money that you want to make sure you make a claim for. And we have actually helped a lot of clients do that. We got $11,000, $33,000 back for clients. So definitely make sure that you do that. So another thing that Ada's father did was he set it and forget it. He got his binder, he took it home, put it on the shelf, never reviewed it, never updated it. Well, you might recall hearing about the tragic accident involving Kobe Bryant, his daughter, and the other members in that plane crash. Well, while she was grieving, Vanessa Bryant, grieving the loss of her husband and her daughter, she had to go to court and petition a judge to allow their youngest daughter, who was not included in their estate plan, to be added as a beneficiary. So if you do not update your trust, you will have to go to court. So updating is very, very important. Now, probate court, as you can imagine, is very invasive, and for someone that is applying or petitioning to act as an executor, for example, has to submit to a lot of requirements, including credit checks. They have to post a bond, and their financial affairs are put out for the judge to be able to decide if they're actually capable of making those financial decisions and acting as a fiduciary. A common mistake when I see estates going through probate is that when it comes to real property, people don't realize that any state that you own property in, if you don't have those properties put into your trust, a probate would have to be filed in any state that you have a house, land, condos, rental properties, any type of real estate. So that means double or triple or quadruple, whatever the case may be, probate, double the fees, the expense, and the hassle, because one probate has to be opened and then several others would have to be opened as well. Another common mistake that I see when it comes to real property in particular is joint ownership. And people presume that because they have their spouse or even someone else as a joint owner on their property, that when they die, that property just goes to that person. Well, it really depends on how the property is titled, because sometimes joint ownership may mean that when one of the joint owners dies, that half of the property has to be probated. There's also some tax consequences, adverse tax consequences, where capital gains taxes may be applied. There's no step up in basis, things like that. So you want to be really, really careful about how your real property is titled. And if you have questions, that is something that we will be talking about. Another example that I'll share with you when it comes to joint ownership is bank accounts. So one of my best friends had a grandmother who didn't have a lot of assets, and she didn't feel the need to do her estate plan. So what she did was name my friend, her granddaughter, as a co-owner on her bank accounts, so that if anything were to happen, her granddaughter would be able to step in and do whatever she needed to do and have access to the money. Well, her granddaughter was married and ended up getting a divorce. And what do you think her granddaughter's husband did? Yeah, he took half, his community property share of the money in the bank. So that was while the grandmother was alive also. So you want to be really, really careful about making decisions without having proper guidance. A common myth that people have when it comes to things like wills, for example, is that they think a will is enough. Well, if you want to avoid probate court, a will will not keep you out of court. It actually has to be filed with the probate court and becomes a public record, and your estate has to move through that very, very long, expensive process. Now, the difference between a will and a trust I'm going to go into, but a will really is just a document that deals with the disposition of your assets. It only says who gets what. And remember, it has to be filed, so it becomes a public record for anyone to see, which was actually what happened also in the case of Richard Harrison. And he was a local Las Vegas celebrity that died a few years ago. And he only had a will. He didn't have a complete plan. That will was filed here in Clark County, and the media got a hold of it and saw that he had disinherited one of his sons. So that became a newsworthy story. Now, I'm sure Mr. Harrison probably thought that this will was going to be a private matter. He probably didn't think that all of his family's dirty laundry would be aired, but unfortunately, that's what happens when you have a will. Aretha Franklin is another celebrity that died without a proper plan in place. So at the time that she died, there was no estate plan that anyone was aware of. Several months later, there was a handwritten will that was found in her home, but regardless of whether there was a will or not, her estate had to go through probate, and her niece was the person that was appointed as an executor. However, it didn't take very long before there was a lot of conflict within the family, judgment, scrutiny on her niece and the action that she was taking as the executor, and she ended up being replaced by someone else after lots of battle and fighting over her aunt's estate. And she is quoted saying, "Given my aunt's love for family and desire for privacy, this is not what she would have wanted for us, nor is it what I want." And that is something that is really unfortunate, but it happens all too often. In Aretha Franklin's case, not only are there going to be a bunch of fees and costs related to the probate, but also estate taxes. So her estate is valued at over $80 million. And because it's over the threshold amount of 11.4 million, her estate is going to be taxed at a rate of 40%. So easily between the probate and the estate tax, plus the other taxes that were owed that came out immediately once the probate was filed, I'm sure the estate will be diminished by at least half. So if you want to avoid probate, when you are filling out the worksheet, please check that box. Now let's talk about the after. Let's do better. We talked about what a will is, and now let's talk about what a trust is. So remember, a will is just a document, very simple. It only deals with the disposition of your assets, who gets what. A trust, on the other hand, is a will substitute, but remember, it does not have to go through probate court. So we are able to create a set of documents, an agreement called a trust, that allows us to completely bypass the probate process. And the trust involves three parties. So there's a grantor, that's the person or people that create the trust. The trustee is the person that is vested with the responsibility of managing the assets in the trust. And the third party is the beneficiary or beneficiaries, the people that receive the assets. Now, while you're alive, if you've set up your own revocable living trust, you play all three roles, right? You're always going to be the grantor, the person that created the trust. You're also the trustee because you have control of the assets and you can do whatever you want, go to the bank, take money out, things like that. And you can receive the assets as the beneficiary. When you're no longer here, a new trustee, a successor trustee, will step into your shoes to make sure that the assets go to the beneficiaries that you've chosen in the way that you want. Now, a trust, as compared to a will, allows for immediate private action, and your assets are available immediately for your loved ones. So those are major differences. The only foolproof way to avoid probate is by having a fully funded living trust with disability provisions. So let's talk about the disability provisions first. Now, when we talk about incapacity, remember, that's if you can't make your own decisions, you can't talk to your doctor, someone else needs to be making decisions for you. And the way that your trust really should be drafted should include incapacity planning to avoid any type of issue where a living probate or a guardianship would have to be filed. When we talk about fully funded, that has to do with your assets. So anything that you own needs to be part of your trust. So as part of the funding process, that means transferring your assets or retitling them into your trust. In this case, think of it as a treasure chest so that all of your treasure, all of your assets are contained within that box, right? We would want to make sure that any investment accounts that you have are put into your trust. Same thing with bank accounts, so that you're not the legal owner anymore. Your trust is, but remember, you're still the trustee, so you have the same level of access and control to your money. Also, if you have real property, we want to re-record the deeds in the name of the trust. Also, stock certificates and bond certificates need to be transferred into your trust. And if you are a business owner, make sure that your business is part of your trust. I'm going to talk about that in just a moment. If you have assets like life insurance, retirement accounts, those are beneficiary designated assets, which means you can name a beneficiary to receive the money when you're no longer here. So with those, we want to make sure that your trust is included as a beneficiary. Whether your trust is a primary or a contingent beneficiary is going to depend on the type of asset and your specific situation, your family situation. Also, your personal property is anything else really that you own. So think of the things in your home, like your furniture, appliances, electronics, artwork, collectibles, your clothes, jewelry, shoes, purses. All of those are personal property items that also need to be part of your trust. It's really important when you're doing your estate plan that we go through a process where we are reviewing all of the assets that you have, we are tracking them, we inventory them in what's called a family wealth inventory so that nothing gets overlooked, nothing gets left out, and your family won't end up having to go through the probate process or get hit with taxes unnecessarily. So making sure that all of your assets, all of your toys are in your trust, in your red wagon, and that includes transferring your assets, right? Updating your beneficiaries, funding your trust. So I work with you to make sure that takes place so that all of your assets avoid court, taxes, and they're available immediately to support your loved ones. Now, if you are a business owner, it's really important that you don't forget about your business. I have a lot of business owner clients that come in, and for those that have planning in place, I always ask them about their assets and what has been funded to their trust. And whenever I ask them about their business, whether that's been part of their that process, they look at me with blank stares. They have no idea what I'm talking about because usually attorneys that prepare documents don't have the business background. So that is one thing that is beneficial to working with us is that I do have the business background and I can make sure that your business is properly funded to your trust because it's a valuable asset, right? You're working now to accumulate your wealth, to build your business, and the last thing that you want to do is allow your business to die when you die. So if you are a business owner and you need a business succession plan, which is basically an estate plan for your business in the event that something happens to you, or if you just need to know whether your business is set up correctly from a legal, insurance, financial, tax standpoint, we do offer business planning sessions for our clients, and we do give preference to our estate planning clients who would like to take advantage of that. I mentioned briefly with Aretha Franklin's estate that estate taxes were going to be coming out of her estate. Now, the IRS always gets its cut first, and you want to make sure that you are aware of what the exemption amount is and the tax rate, and that your planning addresses that. So the tax rate right now is on the low end of 40%. It usually ranges between 40 and 55%. It's been as high as 75%. The exemption amount is something that we call the freebie amount. So right now it's pretty high. It's over $11 million. And so if you have an estate that's valued at less than that, you won't be subject to a federal estate tax. There may be a state estate tax though, depending on where you live. But anything over that exemption amount will get taxed. So for Prince, he was a celebrity that didn't have a proper estate plan in place, and his estate was valued at over $300 million. How much do you think the IRS got from Prince's estate? It was around $120 million. As you can see, he probably wouldn't have been happy about that, right? All of that money just went right to the government right off the top. So now let's talk about the after situation. Let's do better. When it comes to estate tax, we can actually minimize or eliminate estate taxes with the right ahead of time planning. So planning ahead is really important, making sure that this is on your radar and addressed properly within your estate plan so that you can actually avoid unnecessary estate tax. So if you want to make sure that your assets don't go to the government, check that box when you complete the worksheet. Another downside to probate, or even having a trust set up, I see this all the time, it's an outright distribution, meaning that your beneficiaries will receive the assets directly from your estate into their name. So about 90% of the trusts that I see are set up with an outright distribution where there's the different ages where the beneficiaries will receive their assets. So for example, age 25, they get a third, age 30, they get a third, age 35, they get the remaining balance. That's an outright distribution, meaning whenever it moves to them, they get it. There's no restriction, there's no oversight, there's no protection. So the assets are actually at risk for any third parties, any creditors. Now, think of my situation where I have my oldest daughters are legal adults. They're 19 years old now. And if something happened and I didn't have a proper plan in place, say I didn't have any planning, and my estate went through probate, at age 19, my daughters would receive my $300 million estate. Just kidding. I don't have a Prince-like estate, but they would receive everything in my estate directly into their names. So think back to when you were 18, 19, 20. If you received even a modest inheritance of a $50,000 life insurance policy, $100,000, $1 million, what would you have done, right? So that is one of the downsides is with an outright distribution, it just goes directly to that beneficiary. They can do whatever they want. And, they might go a little crazy, right? With no restrictions, no oversight, no protection. So if you want to make sure that your kids or your beneficiaries, whoever that may be, doesn't inherit money at age 18 or in an outright distribution, go ahead and check that box. Now let's do better. Let's talk about the after. When it comes to your distributions, instead of doing an outright distribution, a better option if you're wanting to protect the assets and protect your beneficiaries is through airtight asset protection planning, which we call lifetime asset protection trusts. So that when you are no longer here, the assets will go from your trust into an asset protection trust for your beneficiaries. So again, think of my example with my family. I've got 5 daughters, and when I'm no longer here, when they are to receive the assets, whether they're young or old, they will receive them in a sheltered trust that is protected from all third parties, including lawsuits, creditors, spouses, the government. And if they are young, they will be able to receive guidance on how to properly manage the assets and protect their inheritance. Because of course, the last thing that I would want is for everything that I've worked so hard for to be passed down to them, and say they're married and they get a divorce. I would never want their spouse or ex-spouse to take half of the inheritance that I've left for them. Another thing, if you do have beneficiaries that have special needs, you want to make sure that that planning is specific as well, because an outright distribution can actually cause a lot of harm to those beneficiaries and disqualify them from receiving benefits from the government that they would otherwise be able to receive. So when they are to receive an inheritance, it's really best that there is some special needs planning involved so that they retain their eligibility to receive whatever benefits they may be needing in the future. Side note here, when it comes to my daughters, in this case, who are legal adults, right? They're over 18, they need their own planning. So even though they don't have any assets really, which most college students don't, they do need to make sure that they have planning in place that addresses things like their incapacity, if they can't make decisions for themselves. Also, the assets or things that are important to them, like digital assets, social media accounts, emails, they really would want to have someone appointed to handle that for them, right? One of the things that we did before they went off to college was we put their planning in place, which was such a lifesaver, because one of my daughters injured herself playing basketball, not once, but twice. She tore her left ACL and her right ACL. And of course, because I'm her mom and I'm involved in things that happen in her life, I was the one that was calling and scheduling her surgery, her appointments, and things like that. The first question that was asked of me is, all right, we know that you're her mom, but are you legally authorized to be acting on her behalf? So this is something that we want to make sure is taken care of, for our young adults that that need planning. So if you want to make sure that your children's inheritance or your beneficiaries, whoever those may be, is protected from things like lawsuits, creditors, divorce, no matter how old they are, be sure that you check that on the worksheet. Now, speaking of kids, I've got the 2 older ones, but we have 3 more daughters. So yes, we've got 5 daughters altogether. Our 3 youngest daughters are still minors. And what I realized actually many, many years ago, when they were all 5 minors and much younger, is we were at risk. They were at risk, actually. And I'm going to share with you a quick story, my date night story. And the girls were home with a babysitter, and Charles and I went out for a date, and we're having a good time. And the thought crossed my mind, what if we didn't make it home? What would really happen to our children in that case? And if you know Charles, he was like, well, dang, way to kill date night. We're supposed to be enjoying some time away from our kids, and you're talking about what if we don't make it home? But it was a real question, and what I realized was if we didn't make it home, that the cops would show up, and they would see that our children were there without a legal guardian, someone who didn't have legal authority to care for them. They would take our 5 daughters out of our home into the care of strangers, into CPS, and a judge would decide who should be caring for them in the short term and long term. So when it comes to short term or temporary guardians, in the absence of proper planning, only blood relatives can serve in that capacity. And that's scary to me, because even though we're blessed to have family members that are here in Las Vegas, there are certain family members that I would never want caring for my kids for even 5 minutes. Now, I also know that there would be a battle over who would be taking our kids in the long term, who would be raising them if we didn't make these decisions ahead of time. And that would be an extended battle, it would be expensive, and ultimately, who knows who a judge would pick. Again, there are certain family members that look great on paper, they present well, but they would be the last people I would want raising my kids. So kids, are usually where we see, and we're reviewing plans, this is an area that I just don't see proper planning done. Same thing with your pets. If you don't make it home and your pets are left outside or even in your home, they're hungry, they may be taken into the care of strangers or maybe taken to the pound, right? So let's talk about the after and let's do better. For your children, it's really important that we have a proper plan for them. So as part of the planning that we do for families that have minor children, we include what's called a kids protection plan. So this is an emergency plan so that your children are always taken care of by the people that you want in the way that you want, no matter what. So it's basically a plan within your plan where we include short-term guardianship nominations, long-term guardianship nominations, instructions to caregivers, instructions to the authorities, ID cards for you to keep with you in the event of an emergency, and medical powers of attorney, plus instructions on how you would want your children raised, any concerns that you have, the legacy that you want to leave behind. When it comes to the medical powers of attorney, those are actually also very handy, especially if maybe you're traveling or your kids are traveling like how mine do for basketball tournaments and things like that. You want to make sure that no matter where they are or who they're with, that they would be able to get medical attention in the event that something happens. Same thing for your pets, right? You can do for your pets what you do for your kids by having a pets protection plan so that your pets are cared for in the event of an emergency and they stay safe as well. So when you're filling out your worksheet, if you need a kids protection plan or a pets protection plan, be sure to check that box. Now, your health is something that I think a lot of us have been thinking about, especially this year, right? Now, if you don't have proper planning in place, the law says that any interested party can make medical decisions for you. And if you're married, many people presume that your spouse just gets to step in, right? Well, that's actually not how the law works. The law says that doesn't presume, I should say, that your spouse has your best interests at heart, or that you would want your spouse making medical decisions for you, for example. And think about why that is. Because sometimes people get married and then they separate. Would you want your estranged spouse making decisions for you, like whether you should be on life support, things like that? Probably not. So now, really more than ever, having proper directives is critical because, as we have seen with this pandemic, there's a lot more that's happening, right? People are being hospitalized, and in the event of a client of mine, her fiance was actually hospitalized due to the coronavirus, due to COVID-19. He didn't have planning in place, and so when she was calling the hospital, trying to get information from the doctors and the staff, they couldn't share anything with her. And of course, she couldn't go to the hospital because he was quarantined. What she heard several days later was that he had been transferred, and she was hopeful that he was being discharged, that he had gotten better, and he was going to be coming home. Well, unfortunately, she found out the next day that he had actually died and he was being transferred to the morgue. So these are all instances of things that are happening now and why having proper planning in place is so, so important, especially when the courts are closed and things are shut down. So in this case, if you don't have planning, you have to go to court, right? And in the event of incapacity, it's called a living probate or a guardianship. And this is where your spouse or your loved one, whoever it is, has to prove that they are capable of making decisions for you. Now, it's a probate judge that's going to be deciding who will manage your medical and financial affairs. And these things like powers of attorney, we see this quite often as well, where people put them in place and then they think that they last forever. And that's not the case. They are actually documents that tend to go stale or expire every few years. So having an outdated power of attorney is really, really dangerous. It creates a false sense of security, and you wouldn't want a loved one to take that power of attorney when something happens to you and they're trying to help you and it gets rejected, right? If you're in the hospital and they try to go to the bank to pay your medical bills and it's declined because it's too old. An example of a medical situation that resulted in a terrible situation is Terri Schiavo. And you might recall hearing about this case. This was a right to die case that started in the 1990s, and Terri Schiavo was hospitalized. She was in a vegetative state. Her doctors basically gave her no chance of coming out of of that condition, and she actually had a healthcare directive in place that named her husband as her healthcare agent. Now, given the quality of life that he was seeing in her future, he decided to remove the feeding tube that was keeping her alive. So she wasn't on life support, but she was receiving artificial hydration and nutrition due to this feeding tube. And when he made the decision to remove the feeding tube, her parents objected, and they took him to court. And the reason why they were able to do that is because the document was not clear, it wasn't comprehensive, it didn't address this type of situation. And immediately a judge ruled that the feeding tube had to be replaced. The family battled in court for over 7 years. It went up to the US Supreme Court. President Bush at the time got involved. Ultimately, her husband was granted the ability to make that decision, but it took years of hospital bills, so all of these medical expenses that mounted, plus the court process, so legal bills, fees, attorney's fees, and conflict for her family. And I'm sure that she thought by having this document that things would have been taken care of, but it wasn't clear. And in that case, all we wanted to know is what she would have wanted, right? Let's talk about the after, and let's do better. When it comes to your healthcare decisions and end-of-life decisions, we want to make sure that they are clear and comprehensive so that you avoid court and that you, not a probate judge, is making decisions as to what happens if you are on life support or if you are to receive medical care. Now, if you have a healthcare directive, you really should be taking a look at it, especially now in light of COVID-19, because what we are seeing is some people that are being hospitalized due to the virus are needing to receive temporary ventilation or intubation, and if that is not provided for in their planning, it's causing some problems. So you want to make sure that those things are addressed. So if you want to make sure that your spouse or your loved ones know what to do in the event of your incapacity and that your decisions are going to be honored, make sure that you check that box on the worksheet. Well, we've covered a lot of ground, right? Let's recap. So lesson number 1 is a review of all of your assets should be part of your estate planning process and conversation. A document alone, like a will, is not enough to protect you. So make sure now you know the difference between a will and a trust and those other documents, and the importance of having a proper family wealth inventory that tracks and titles your assets properly from now going forward so that nothing gets overlooked, things don't get left out and have to go to court or get lost to the state's unclaimed property department. Number 2 is the IRS always comes first, but you can protect your assets and you can give your assets to your beneficiaries, your loved ones, with the great gift of asset protection at really low cost. So this is something that we do give clients the option to build in within your planning. Lesson number 3 is guardianship is equally about what happens in an emergency or short-term situation as it is about the long-term, like who would raise your children. And remember, your pets. Lesson number 4 is the only person other than you that can make your decisions is a probate judge. So do not let that happen. Make your decisions now while you are alive and well. So number 5 is if you want control of what happens to you, your loved ones, your assets, you have to act before it's too late. Unfortunately, we get a lot of calls from people saying, hey, like my aunt is experiencing dementia. She's got the onset of dementia and we need to put her planning in place right now. Well, once someone has diminished mental capacity, we can't just put planning in place. You would have to go through the court process and petition a judge in that situation. So don't wait until that type of thing happens. Do it now while you can. The bonus lesson here is, what is it really like for your loved ones after you're gone? They're going to miss you, right? And what is it that they're going to care about most? Your legacy. So what is your legacy? Your legacy is your insights, your values, your stories, your experiences, your family traditions, your culture, all of those intangible things that really are priceless, right? For me, the legacy that I want to leave behind is going to be left to my daughters, my nieces and nephews. And I think about if something happened to me today, most of them are very young, including my youngest daughter. She's only 9. And so if something happened, she would have very few memories of me growing up, right? And I would miss things like high school graduations, college graduations, wedding days, first babies, all of these milestones in life that I would want to be part of, to share in that experience and share what I know about life, right? So that is one thing that we do include as part of our planning, is a legacy component. So it's legacy planning for families so that those things are captured and you are able to show your love in an intentional way, and hopefully things happen and you'll be able to live a long, long life, healthy life. But if anything were to happen, we have those pieces in place. I want you to remember now why you're here. For me, of course, it's my family, and they need me to have a comprehensive plan in place to protect them. Now, we all have choices, right? So now you've got 3 options as far as how you move forward from here. Option 1 is you can do nothing. And as you know, by doing nothing and keeping your blinders on, you know what can happen, right? Or you can rely on some form documents, that may have been drafted maybe by an attorney, another attorney that practices in the traditional way, or online. And as you can see, when they're not complete, they're not comprehensive, they are ineffective, and you can end up in court and conflict or worse. The third option is having a tailored plan that is customized, it's personalized, and actually works for you and your family the way that you intend it. Now, the risk with doing things online, or even with working with another person like an attorney or a document preparer, is that if you are seeing things like the $99 will, or you're getting quoted $1,000 for a trust, or $1,500, or whatever, a quote for your trust ahead of time, those are going to be form documents. They are not going to be customized, because at that price point, they're not able to. So you really get what you pay for when it comes to your planning, and you want to make sure that you are looking out for those red flags with the traditional experience, unfortunately, which usually is focused on death. And I think that that's why a lot of people just don't want to think about it, and they don't want to take action. And also, many times it is based on hourly fees, so it gets really, really expensive. And they're based on form documents, cookie cutter, one-size-fits-all documents that aren't going to work the way that you really want them to. If there is a response, it's a knee-jerk response to problems, and it's very transactional, right? Where you go in, you get your documents, you never hear from the attorney again, you're just a transaction. If you call the office, they don't answer, they don't return your phone calls, they're not keeping up to make sure that your plan is reviewed and updated properly. What I think your experience should be is really focused on life, right? So that you can make decisions now, have true peace of mind, knowing that things will be taken care of the way that you want them to be. And it's where the fees are flat fee, agreed to in advance. I'm going to talk about the fees in just a moment. Where you're planning now to avoid problems later. And it's relationship based, so that when you come in and you do your planning, it's really the beginning of the relationship. Because as time goes on, and I want to be your lawyer for life, as your life changes and the law changes, I want to be there to make sure that your planning stays up to date and current as those things happen. So my promise to you is that your estate plan will leave no stone unturned, and it will give you true peace of mind, knowing that your loved ones, your assets, and everything that you loved will be handled the way that you want, kept out of court, kept out of conflict. So my goal really is to achieve lifetime relationships, not one-time deals. Now, I told you I would talk a little bit about the process, and the process starts by starting the family wealth planning session. So that's where you can book. Actually, right now you can click on that button that says book appointment, and you can schedule your complimentary family wealth planning session. That's a 2-hour meeting with me, where we're going to talk about all of the things that are important to you. What questions you have, the family dynamics, the concerns that you have, so that we can address them and we can talk about your goals and we can put a plan in place. So before you come in for your family wealth planning session, I do ask that you do a little bit of homework. It's called the family profile, and it really does help you get financially organized. I have a lot of clients, who likes homework? Not many of us, but clients will come in and they'll be so appreciative for that experience, because it helps gather their thoughts, gather the information so that we can move forward in the best way possible. So I tell clients, don't feel overwhelmed when you're doing the homework. Just do the best that you can. We don't need all of the account numbers and all of those details, but at least identify the assets that you have, the approximate value, the people that you're concerned about, the other values that are important, so that we can talk about it when you come in for the family wealth planning session. Now, the family wealth planning session is the first meeting. After that, we have a signing ceremony and a third meeting. I'll talk a little bit more about that. But at the family wealth planning session, that's where we will talk about your specific situation. I'll answer all of your questions. I'll do an analysis of your current plan, whether you have documents in place or not. And we will talk about what your concerns are and how we can address them. I will give you options on how to achieve the results that you want. I'll go over the different levels of plans, the features that are included in each level, and then you'll be able to pick the type of plan that you want and pick your fee. So the typical fee range for our comprehensive plans is usually between about $2,000 and $5,000. Now, it could be more, it could be less. It really depends on what you need and what's important to you. All of our planning includes every 3 years a complimentary review of your plan, because remember, things like powers of attorney tend to go stale. So at a minimum, every 3 years, we really should be looking at your planning. Or you do have the option of joining our VIP program. And if you join that membership, there's an annual payment, an annual fee of $250 a year. One of the benefits is an annual review of your plan. Plus, if there are changes that you're wanting to make, they are either discounted at 50% off or they are complimentary. So there's a bunch of other benefits to VIP membership that we can talk about if you are interested in that. But also remember that there are starter plans available. So if you don't need a comprehensive plan, there is planning that we can do. So it is customized to what you need, so that you are actually creating a personalized plan for your loved ones that captures all of your wealth, including your financial wealth, your family wealth, and you're going home with true peace of mind, not a false sense of security, and you're making decisions in a time of convenience, not a time of crisis. So now you've invested the time. You are now educated and you know what would happen. You know the realities of what happens if you do nothing, or if you rely on a flawed or incomplete plan that won't work. And you're probably sitting with the desire to take a look at your own personal situation. Now, when you're filling out the worksheet, or if you've thought about, oh yeah, I need to check that box, that is an indication that yes, you definitely need to schedule a family wealth planning session. And now I'm going to make an invitation to you. I want to make it easy for you to do right for yourself and by your loved ones. You know, do you want to put this off longer, or do you want to take the next step? Well, I want to make it easy, like I said, so I'm giving you this complimentary family wealth planning session. Normally, the family wealth planning session is $750, but because you are here and you are educated, I will gift that to you now. So go ahead and schedule. And by scheduling now, scheduling today, you will receive a bonus of $250 off your plan. So that is a significant discount, right? $250 off your plan. The reason why I do that is because I don't want you to get stuck in procrastination. The risk is not that you don't love your family, or that you won't invest the time or even the money. It's that you will procrastinate and you will allow other things to become priority. And I don't want you to get stuck in that. So I want to make sure that you're able to take action now to do what you need to do to get that peace of mind. And it also saves me time, right? Because you're taking action now. So go ahead, book your session by clicking on the link below. And we are featuring virtual services where you can complete your planning from the comfort of your own home. So we can do that. If you have questions, you can reach out as well. You can call the office at 702-473-5600. You can also email me directly, shane@younglawnv.com, or email client services with any questions that you have. But if you do have questions, really the best way to address all of them is at the Family Wealth Planning session. And you can also get more information on any of our virtual services and upcoming events at younglawlive.com. If this has been helpful to you, please share it. Please share the website. Our on-demand video is also available, so if someone can't make it at the scheduled time, there's always that replay there. They go pretty quickly, so I encourage you to go ahead, schedule your family wealth planning session now. Reach out again if you have questions. We are here to answer them. I hope that you will take advantage of the opportunity to get this planning in place now and take advantage of the complimentary family wealth planning session. It is a 2-hour session. It doesn't always take that long. Sometimes it may take a little bit longer, but it is really a great opportunity for you to get all of your questions answered. And also what we do at the family wealth planning session, once you pick your plan and you pick your fee, you're the one that's deciding how much your plan costs. We go right into the design of the plan. So it really is a working, productive meeting where you're leaving with something actually done. We're building your plan together. So we want to make sure that you're in a good position. Another question that comes up is the payment. There is going to be a payment that's due at the family wealth planning session for any planning that you decide that you want to do. So after you've picked your plan, picked your fee, we do the design. When we're done with the design, we go over the engagement agreement, we talk about any action items or next steps, and you will make a payment. You have options on how to make payment. If you make payment in full with a bank or a check, there is a discount that's applied. Also, same thing if you're paying in full with your credit card, or if you want to split the payments, we can split the payments and do a 50-50 plan where you pay half at the family wealth planning session, half at your signing meeting, which is usually about a month from a month out. If you're splitting the payments, there is no discount applied. And if you need some more help as far as breaking out the payments a little bit longer, I will work with you. The goal really is to make planning available and accessible for people that want to make it a priority. So I will work with you to make sure that it happens. Go ahead and book your session now so that you can take advantage of getting the complimentary family wealth planning session plus the $250 discount off of your plan. I hope to see you soon. And remember, in a world where you can be anything, be kind.